Good morning or good afternoon, everyone, depending on your location. Welcome to the latest in our series of webinars on critical legal developments affecting tobacco control. Thank you for joining us today. My name is Doug Blanke, and I direct the Public Health Law Center in Minnesota, home of the Tobacco Control Legal Consortium. I hope everyone on the line today is familiar with the consortium, the legal network supporting tobacco control in the United States, providing legal technical assistance and guidance on every aspect of comprehensive tobacco control. If there's anything that we can do in any aspect of your daily work that would be helpful, we hope you will let us know. Today represents the 62nd webinar in this ongoing series, but I doubt that we have ever offered a program that was more timely or more important than the topic we're going to be discussing today. If you have been following the news at all over the last week, you will have been hearing about something called the Trans-Pacific Partnership, or the TPP. Maybe you read over the weekend that the final stage of negotiations after years of efforts were hung up on a number of different issues, and that one of them involved the treatment of tobacco products. And if you didn't catch that development, you probably did hear the news yesterday that all of the last-minute impasses had been broken and that agreement had been reached, concluding more than 5 years of negotiation on what could be the world's largest free trade agreement. This is an agreement that would affect 40% of all global trade and that is being called the capstone of President Obama's Asian policy. But at the same time, it is also a key battleground in a global struggle against the multinational tobacco companies. The fact is that the world's tobacco control community has become more unified and has maybe begun to follow that old adage to think globally but act locally, while at the same time the tobacco companies have developed a new strategy to undermine our progress by adopting the opposite approach, thinking locally but acting globally. What I mean by that is that they've learned that when we succeed in changing the norms and cultures and laws of our own countries to protect our populations, they may sometimes be able to circumvent everything we have done by taking the battle to a distant arena that we aren't even thinking about, the arcane but all-important world of global trade, a world where everything is designed to promote the sale of goods and products and where health can be little more than an afterthought. We recognize that tobacco control professionals don't spend much of their time thinking about the world of international trade if it ever crosses their minds at all. If it does come up, everything sounds so unfamiliar and so complicated, the terminology is so foreign to us, that our natural tendency may well be to ignore it and to turn back to the work that we are most familiar with. Well, that's exactly what the tobacco industry is hoping we'll do. Leave them continuing relatively unhampered as they pursue strategies with the potential to undermine everything else we do. So whether you are working in a local health department in Nebraska, at a national health advocacy organization in Washington, or in a state legislature, or wherever you are, the message we want to bring you today is that this affects you and we all ignore it at our own peril. We could not have assembled a more distinguished panel than the three speakers who are here today to demystify all of this for you. They will be speaking not just about this week's news developments, but about the larger context that makes this all so important. They will be explaining how trade agreements and trade litigation far from our shores can threaten everything we do at home. Our panel comprises some of the world's leading experts, each of whom has been deeply immersed in the treaty negotiations, the global litigation, and the congressional wrangling. We are so pleased to bring them to you today. You will be hearing from Chris Bostick of Action on Smoking and Health and the Framework Convention Alliance, the Global Confederation of 500 Tobacco Control Organizations. from Greg Hafley, who leads these issues for the American Cancer Society's Cancer Action Network, and from Ben McGrady of the World Health Organization. I will introduce each of our speakers before they present. When all three of them have concluded, we will take your questions, which you will be able to submit by way of the Q&A window on the lower right-hand side of your screen. Our first speaker today is Chris Bostick, Deputy Director for Policy at Action on Smoking and Health in Washington, and Legal Counsel to the Framework Convention Alliance, the voice of the global tobacco control movement in implementing the Framework Convention on Tobacco Control, the engine of progress in global tobacco control. Chris holds a master's degree in foreign service from Georgetown and a law degree from American University. Before joining ASH and the FCA, Chris worked at the American Lung Association and the Campaign for Tobacco-Free Kids. He has been involved in the negotiations for the Trans-Pacific Partnership from their inception. Chris?
Thank you very much, Doug, and thanks everyone for being on the call. As Doug mentioned, it's particularly exciting to be having this call today. We could not have foreseen it when we were planning this webinar, but a note before I get started on trade in tobacco. This has been a long road, and we certainly are not at the end of that road as of yesterday. I was involved, as Doug said, in the FCTC, the Framework Convention on Tobacco Control negotiations. Trade was part of that discussion, and we were unable to get trade dealt with in the FCTC. If you read the text today, there's no explicit mention of trade unless they're talking about illicit trade or smuggling. So there's a long way to go, but we're still kind of riding high today after yesterday's news. So a bit about the ongoing tobacco epidemic to put this in context. I think people in the United States, even people that work in public health, can be forgiven for thinking that the war on tobacco is largely won. We've made tremendous progress in this country in the 51 years since the original Surgeon General's report. Tobacco prevalence is extremely far down. Yesterday I was at a conference, and in many places it's down below 15%, and that's fantastic news. But from a global perspective, we have a long way to go, and there are more smokers in the world today than there were yesterday, and no matter what we do today, there will be more smokers tomorrow. And the curve for the globe is very different from the curve in the United States. And this is just a standard curve for how the tobacco epidemic plays out. The United States and many Western countries are clearly in stage 4. And if we continue our efforts, the line will continue to go down. But in many parts of the world, the tobacco epidemic is in stage 1 or 2. And that doesn't mean that they're doomed to reach those further stages, but it does mean that we have a chance and a risk. A chance to do something about it, and a risk that if we don't, we're dooming new countries to the same level of death that we have here in the United States. And this is not going to be a presentation on the epidemiology, but I just wanted to give one slide to give an example of what's going on in the world. This slide shows female smoking prevalence around the world, and the light countries are the countries with the lowest female prevalence. The tobacco industry sees this map in a very different way than we do. They see it as a potential for huge growth. And in the United States, a century ago, very few women smoked. And through marketing, the tobacco industry was able to increase that. They are doing that now in Africa and in South Asia in particular. So when they see a country like Vietnam that has a 4% female smoking rate, they see the opportunity for a 25-fold increase in their market. So we have the chance to do something about that, but the tobacco industry is very well funded and very determined to increase their market share. So a little bit about the globalization of the tobacco epidemic. In the 1990s, the tobacco industry could see the writing on the wall for the United States and other Western countries that public health measures were increasingly going to cut into their profit margin, and they looked to the global South as their next big market, and went there with gusto. In most of those countries, there were no public health measures, there were no advertising restrictions, there were no smoke-free air restrictions. And so it was a wild west for the tobacco industry, and they were wildly successful and realized early on that when you're selling an addictive product, poverty doesn't matter that much, that people once addicted will find a way to buy your product. So in 1999, the world responded by beginning negotiations on the Framework Convention on Tobacco Control under the auspices of the World Health Organization. And this was the first and still only global public health treaty. And as such, it was unique, and the world really did come together in a way that it hasn't on many other issues, aside from maybe HIV/AIDS. In the 2000s, the tobacco industry also went global in terms of its litigation strategy. And we'll talk much more about that, but it's a continuation of a long-term strategy that they've used to use litigation to block or delay meaningful tobacco control regulations. So a little bit about the global mechanisms to understand and defeat the tobacco epidemic. The first I've already mentioned, I'll talk more about in a moment, is the FCTC. It's very comprehensive, but it has its issues, and one of those issues is implementation. It's been enforced for just over 10 years, but implementation has been spotty around the world. But we have some new mechanisms that are helping us on that. In 2011, there was a United Nations Summit on Non-Communicable Diseases, or NCDs, including a roadmap for addressing those diseases. And tobacco is the one risk factor that is true across all of the non-communicable diseases, and it is the leading risk factor for non-communicable diseases. So in order to address NCDs, the world will have to further address tobacco. And then just 2 Fridays ago in New York City, the United Nations adopted its Sustainable Development Goals. And this will set the agenda for development, not just from the UN, but from bilateral development agencies for the next 15 years. And for the first time, we were able to get tobacco control as part of those goals. And so FCTC implementation is written in as something that countries ought to be doing and that development agencies ought to be funding. And then last, I wanted to mention very quickly human rights mechanisms. This is still a new territory for us in the tobacco control world. We're coming at this from 2 approaches. One, as a way to enforce implementation of the FCTC, since the FCTC does not have an enforcement clause. So we can use things like right to life, and right to health to enforce measures under the FCTC, and also as a way to do shadow reporting on FCTC implementation, which is something the Framework Convention Alliance has done for several years, but has run out of funding. And so this is a new method for holding governments accountable for their obligations. So a little bit on the Framework Convention on Tobacco Control. This is a very comprehensive treaty. It includes what is still, I think, a complete package for tobacco control and for tobacco use reduction. It's one of the most quickly and widely adopted treaties in history. To date, it has 180 parties. That's 179 countries plus the European Union. As I'm sure you're aware, the United States is a signatory but not a ratifier of that treaty. Ratification includes about 90% of global population. And it is a framework convention. Like other framework conventions, it was intended to be an ongoing effort. And so guidelines for various substantive articles have been promulgated over the years. And we're almost to the point now where there are guidelines on every substantive article under the FCTC. And I won't go read the whole screen, but those guidelines are for almost everything you see there. But I did want to point out that the 2 in the bottom right corner, industry interference and litigation, are articles under the FCTC, and that's what we're going to be talking about today. So this is a quote from a very wise man that helped put together a report in 2000. It just shows why this is a different issue than it is for other public health issues and disease issues in the world. We are facing an incredibly well-funded multinational industry. I think last year, their revenue for the tobacco industry, the multinationals, approached $750 billion. And so when we're talking about the costs involved in litigation, these are rounding errors for the tobacco industry, but it's real money for governments when they have to defend themselves. So just a bit about industry interference. I'm sure you're all aware of this, but just for the sake of the argument, I just want to briefly go over them. It includes lobbying. It includes local contribution. It includes the use of front groups. It includes funding bogus research or simply funding research at universities to preclude them from doing research on tobacco control. And then finally, it includes litigation. So some of the goals of litigation, and these are not mutually exclusive, are to block, delay, or to create legal chill for governments. And the legal chill really does work back towards blocking and delaying. So just to give a couple of examples, we know that Togo promulgated plain packaging regulations last year or 2 years ago, and under threat of a trade lawsuit decided not to implement it. So they were successful in blocking it without actually even launching a lawsuit. The delay can be seen in New Zealand, which was prepared to move forward on plain packaging following their Australian neighbors, but decided 2 years ago to put that off until they saw how the trade litigation in Australia is facing, and that Ben will talk more about, comes out. And so the tobacco industry is already being successful using these tools. This is not a hypothetical threat to our tobacco control efforts around the world. So a little bit of history of trade litigation. In the 80s and 90s, the tobacco industry was successful in using country champions to go after other countries to pry open markets for their products. And the number one champion for those efforts was the United States. And the tobacco industry was successful in getting the U.S. to force open markets that had been previously dominated by domestic monopolies, and especially in East Asia. And once those gates were opened, we can look back and see that it had devastating impact on the public health in those countries. That within a year, in 4 East Asian countries that had their markets opened up, prevalence rose 10% because of the marketing savvy of multinational tobacco companies that had not been there before. So starting in the 90s and moving forward and getting bigger and bigger as a snowball was the rise of so-called investor-state dispute settlement mechanisms in trade and investment agreements. And these have now reached the point where there are about 3,000 bilateral investment agreements with ISDS provisions in them. And of course, an ISDS provision allows a corporation to directly sue a government for loss of profit over regulations without the need for a champion. And as Doug mentioned, in addition to that, these cases are heard before foreign tribunals that are behind closed doors. There's no appeal process. It's not subject to a domestic Supreme Court. And often the judges on those tribunals are taken away from their day jobs working for corporations. And so often they don't see public health or environment or labor standards as being the primary issue. They see increase in consumption, increase in profit as the primary issue. So I just wanted to, Ben is going to talk much more about this, but I just wanted to use the Australian plain packaging illustration to show the litigation efforts of the tobacco industry. Australia it has been and is still a leader in tobacco control in the world, and several years ago promulgated plain packaging for all tobacco products. The industry responded domestically, of course, with a massive marketing campaign to try to get it defeated at the parliamentary level, and it failed. They immediately launched a domestic challenge under constitutional law, which fortunately they lost. And so that case is finished. They also managed to get the Ukraine and then 4 other countries to file lawsuits under the World Trade Organization rules. Ukraine has since pulled out of those, but the other arbitrations are still pending. And then finally, the tobacco industry was able to use a bilateral investment treaty between Hong Kong and Australia to launch one of these ISDS suits. And there was some shenanigans played there in order to get jurisdiction. Prior to the advent of plain packaging, there had been no investment from Hong Kong Tobacco to Australia. They managed to shift some ownership around in order to be able to take advantage of that treaty. So a little bit about what the costs can be and how legal chill comes into play here. We've done some research over the last several years with the Harrison Institute at Georgetown Law School on the costs of ISDS litigation, and the average cost is $3 to $8 million per case. And for a developing country, that's real money. And for the vast majority of developing countries, it dwarfs their annual tobacco control budgets. So that would be bad enough. But it came out about a month ago that if you package all of their litigation costs together, Australia has already spent about $38 million defending their plain packaging. And even for a developed country, that's a big price tag. So even though everyone is fairly certain Australia is going to win, other governments are going to shy away from passing plain packaging or something similar in the face of such a threat. So regulatory chill is a very difficult thing to prove because it's difficult to find a government willing to admit that it didn't move forward because it was frightened away by trade litigation costs. But as I mentioned, New Zealand has said that it will not implement plain packaging until it sees how Australia's case goes. Uruguay was ready to back down from its threat from an ISDS suit from Philip Morris International But then former Mayor Bloomberg stepped forward and subsidized their legal defenses. So they're still involved in their case, but otherwise would have dropped out. We do, as I mentioned, Togo had decided not to implement plain packaging, and we know that both Namibia and Papua New Guinea have also backed down in the face of private threats from the tobacco industry. We don't know what other governments have shied away from moving forward on tobacco control because of the threat of trade litigation. It's very difficult to find out. In fact, we found out about several of these countries because of the investigative journalism of the John Oliver show earlier this year. Otherwise, we wouldn't have known about 3 of these countries, but they found the smoking guns. So I wanted to be very quick because I think that we're going to have a very vigorous question and answer period. I will be able to stay longer than the hour if people want to keep talking, but if you want to ask me a question offline, I'd be very happy to engage with you. Thanks very much.
Thank you, Chris. Our next speaker is Greg Hafley. Greg directs federal relations for the American Cancer Society's Cancer Action Network, the Washington-based action arm of the Cancer Society. Like his fellow panelists, Greg's training is in law. Before joining the Cancer Society 8 years ago, he held senior positions at People for the American Way and at the Children's Defense Fund. Greg not only leads the Cancer Society's work on Capitol Hill, but he has also been deeply immersed in the trade issues we are discussing today. Greg?
Thank you very much, Doug, and thank you for putting this webinar together, and thank you to all of the participants for joining. It's an exciting day, obviously, because of, as Doug mentioned, the reaching of a new trade agreement. But the fact that they have reached an agreement is only one step along the way of how we have to be vigilant to address the issue of tobacco in the trade context. I'm just going to do a little bit of a setup because I think as I talk to folks on Capitol Hill and to folks in the administration and to folks in the media about this issue, it's important for them to have some context to why we are trying to address the tobacco crisis in the trade context. First of all, about tobacco products. I mean, clearly it's unlike any other legal consumer product. Its actual impact is to kill 1 in 2 of every long-term smokers. And that is in part because it is an incredibly highly addictive product. There are no benefits to tobacco, contrary to the arguments that the tobacco industry and some of its proponents will make, in particular in developing countries where they encourage and facilitate the growing of tobacco and where they are building tobacco manufacturing plants to make the argument that they're engines of economic growth for low and middle income countries as opposed to being a drag on their societies, which they actually are. Tobacco is the #1 preventable cause of death in the United States as well as around the world. It killed 100 million people in the 20th century globally. And this is a staggering number when I talk to people about the impact of tobacco and why we do this kind of work. Tobacco is projected to kill 1 billion, and that's billion with a B, people in this century, unless governments take urgent action to address the tobacco crisis. In the trade context, I think it's also important to put tobacco in an economic frame because the people who do trade work, the people who work in the trade ministries, the people that do the advocacy for their products and economic sectors to get the benefits of increased international trade, always try to make the case that there's an economic benefit to the promotion of tobacco. But in fact, I think it's really important to reframe the debate in the trade context, in part because we know that tobacco causes health care costs increases for families and nations. That's money that they could be spending on other products, goods, or services. It is a significant drag on worker productivity. We have projections of the economic productivity costs of tobacco in the United States, and we know that that's true around the world as well. It diverts resources away from other products and infrastructure. I mean, the money that countries could spend on the development of ports, railroads, highways, all of which facilitate international trade, are diverted to, frankly, healthcare expenditures that could be otherwise avoided if tobacco is successfully addressed. And at the end of the day, when you put everything together, we think that tobacco is an incredibly anti-economic development product and industry, and that ultimately it's not beneficial to the rest of the trade and business community in the trade context. And I have to emphasize to people over and over again the unique aspects of tobacco and why it should be treated differently in the trade context. We've already talked about its addictive qualities, and its deadly impact. But we should also talk about the aggressive and abusive behavior of the tobacco industry. And they do it in a lot of different ways. They do it with manipulation of the product itself. They do it with incredibly aggressive marketing tactics, both to keep smokers smoking and future prospective tobacco users to get them to take up the consumption of the product. And then once we are successful in securing whatever gains we can make in the interests of public health and public policies around the world, the industry aggressively uses litigation to try to block us. And then finally, as Chris said, as he was talking about the Framework Convention on Tobacco Control, it represents the only international health treaty. That's a global consensus on the steps that nations should be taking to address the tobacco problem, to reduce consumption, and to save people from disease and death. So you have to talk about tobacco all the time in terms of its unique impact, its unique aspects, and the unique behaviors of the industry. Now, the work that we do in tobacco control, as Chris mentioned, involving some of the trade litigation, has crashed head-on into the world of international trade. The tradition in the trade world, and that is something that is particularly exciting about what happened yesterday, but the tradition in the trade world has basically been to treat tobacco as just another business and just another product to be promoted all around the world. There are more than 3,000 bilateral investment treaties, as Chris mentioned, that contain provisions that give the industry the right to initiate on their own international trade disputes. And there are also hundreds of free trade agreements around the world, or regional free trade agreements, that also contain the provisions that give industry the right to initiate disputes on their own. And basically, that allows the tobacco industry to thwart or attempt to thwart the sovereign governments of the world and the public health community efforts to stop the spread of tobacco consumption and begin the decline of tobacco use. And they use that kind of litigation to challenge labeling and packaging requirements and in other ways as countries try to advance their public health objectives. And Ben will talk a little bit more about some of the specific disputes. But just like in the United States, where the tobacco industry has used domestic court litigation to try to block graphic warning labels on cigarette packs, for example, the tobacco industry has been using trade agreements to generate those same kind of disputes in the international trade context. We have some formidable opponents as we try to work on these issues. Business associations, including such associations as the U.S. Chamber of Commerce and the American Farm Bureau, oppose us as we try to change the treatment of tobacco, both as we advocate for domestic tobacco control policies, but also as we've been doing work in the international trade context. They argue that treating tobacco differently discriminates against a legal business and a legal product, that people should have free choice, and that it's unfair to treat tobacco differently. And they actually argue that it's discriminatory against that particular sector, despite the fact that governments around the world agree that there's the need to address the tobacco crisis. They always frame it as an attack on an agricultural product sector. The tobacco industry is artful in hiding behind the growers and the retailers. And they've done it aggressively in the trade context, and they will continue to do that. And we have to call them out on that kind of behavior because, as you'll hear in a little bit as I describe what happened in the TPP negotiations, some of the claims that they make about growers just aren't true. They argue that it's a slippery slope, that it's first tobacco that's going to be signaled out and then it's going to be something else. You know, they frequently point to, sugary sweetened beverages or snack foods or fatty foods or alcohol or other products. I think that we're in a situation where, there's so much that's unique about tobacco that it's going to be a while before we see anything done in some of those other areas and the international consensus can be reached on how to address some of those other issues. And then finally, and this is almost laughable, but we actually have members of Congress who are making the argument that discriminating against tobacco is against our values, as if the value of tobacco products is bigger than the value of the lives we will save if we're successful in regulating tobacco. And they also argue that it's against our legal standards, although, I think that argument is one that only works in the sense that they want to be able to sue in any venue they can and continue the business as usual practices that they engage in. I've already talked about the unique aspects of tobacco, but it's always important to be able to reiterate those. Now let's talk about the TPP negotiations, because for one of the first times ever, we've had a significant movement to get tobacco treated differently in the TPP negotiations. There were basically two approaches that were proposed. One was to exclude tobacco completely from the trade agreement, and what that means is that in addition to cutting off the litigation rights, it would have prohibited tobacco from benefiting from any tariff reductions and any other aspects of the trade agreement that the industry may be able to try to take advantage of. And then there was the proposal of the United States that was ultimately accepted in the TPP negotiations that looked to the specific abuses by the tobacco industry of the litigation rights that are granted under trade agreements and basically cut them off to protect tobacco control measures in the TPP countries. The proposal that, as we understand it, and the language won't be available for several weeks, so we haven't seen the exact text, but it's been reported that governments that are parties to the TPP agreement will have the right to protect their tobacco control measures by asserting the denial of the investor state provision benefits for use against tobacco control measures. And as we understand it, the tobacco control measures provision is a rather broad or comprehensive set of measures that would cover the product manufacture or composition of tobacco products, the distribution, labeling, packaging, advertising, marketing, promotion, sale, purchase, or use of tobacco products. So it appears to be rather broad, but again, we'll have to see what the exact language is to know for sure, how comprehensive the definition of tobacco control measures is under the agreement. As I said, the agreement was reached about 31 hours ago, but now we're set up for months of debate in the United States Congress, and governments around the world that are parties to the TPP will have to go through the process of approving the trade agreement. So we're going to be seeing a lot of debate about this issue in the United States Congress. Most of the debate is coming from the tobacco growing states, members of Congress, who continue to argue that this is an attack on tobacco growers and are threatening to withhold their votes for approval of the trade agreement. Obviously, the proposal in the TPP will not be able to take effect unless the agreement is approved. And so stay tuned for, what will happen in Congress and governments around the world going forward relative to the TPP. Finally, I think it's important to emphasize that this is a precedent for new trade agreements that may be developed in the future. It's the first time that tobacco has been treated differently, and that is historic. And so I think that we've got our work cut out for us looking forward, but we certainly have something now that we can hang our hats on and use for future advocacy in the trade context as well. So I will end it with that and turn it back to Doug and look forward to the questions folks may have at the end of the discussion.
Thank you very much, Greg. Our final presenter today is Dr. Ben McGrady, Legal Technical Officer in the World Health Organization's Tobacco-Free Initiative. I think Ben may have earned more educational degrees than the rest of us put together, so we treat him with particular respect. Ben holds both a bachelor's and a master's degree in law, as well as a PhD in international trade. A native of Australia, Ben was active in development of the FCTC, where he served as the Framework Convention Alliance's go-to expert on trade. He then moved to Georgetown School of Law, where he directed the O'Neill Institute Initiative on Trade, Investment, and Health. Today, he's the WHO's leading expert on issues of tobacco and trade. I will also mention that Ben and his wife are expecting their second child within the next week or so, so if Ben should have to leave the webinar unexpectedly, I think we will all forgive him. Ben?
Thanks very much, Doug. Thanks for the invitation and thanks for the kind words of introduction. I'm pleased to announce that my wife is not in labour, and if it does happen, then yes, certainly I'll have to step away from the computer. The presentation I'm going to give today is really just to give a brief outline of some of the contemporary disputes under international trade and investment agreements, in a sense by way of background. That is, we've heard a lot about the discussion in the context of the Trans-Pacific Partnership Agreement, but in reality this issue would not be on the agenda, and certainly wasn't on the agenda before the types of disputes that I'm going to discuss in my presentation in a moment arose. So it's worth recognising, I think, that there's been a long history of discussion, particularly in the public health community and the tobacco control community, around the implications of international trade and more recently investment agreements for tobacco control, but it's only really reached a sort of critical point and reached the headlines in the New York Times, the Washington Post, etc., as a consequence of the disputes that I'm going to mention briefly now. So by way of overview, we have a number of different types of claims under different types of agreements, and it's important to recognise the different, I think, political and legal dynamics that underlie each of these different types of disputes and agreements. So we have investment treaty claims against Uruguay and Australia, and they utilise bilateral investment treaties that are largely similar to investor protection chapters that we see today in free trade agreements, and that's in fact the chapter that has been mentioned already by Chris and Greg with respect to the specific tobacco provision in the TPP negotiations. We also have claims under the law of the World Trade Organization in the past few years, one against the United States with respect to its tobacco product regulation, its ban on flavours with the exception of menthol, and then today on foot we have a number of claims against Australia with respect to tobacco plain packaging. We're also beginning to see claims under the law of the European Union, specifically with respect to plain packaging in Ireland and the United Kingdom, but then also with respect to the 2014 EU Tobacco Products Directive. After giving a very brief and basic outline of those disputes, I'll turn to the question of what happens next. And obviously there's a significant discussion around getting the TPP through Congress, and I'm sure that different organisations in the United States are now trying to work out what their position should be exactly on the agreement. But I'll focus not so much on the domestic US scene and politics, but more broadly on the question of what happens next at the global level and what are the next steps that could be taken to improve the situation for public health. So, Philip Morris versus Uruguay, I think, is an important dispute that deserves first mention. As many of our listeners online will know, Philip Morris has brought a claim against Uruguay under the bilateral investment treaty between Switzerland and Uruguay. For those not familiar with these agreements, the bilateral investment treaty effectively protects the assets of Swiss investors when invested in Uruguay and Uruguayan investors when invested in Switzerland. Philip Morris International is based in Switzerland and therefore for purposes of the treaty is a national of Switzerland. The claim challenges two measures. First, the size of the health warnings implemented by Uruguay. They cover 80% of the front and back of cigarette packaging. At the time it was implemented, that was the largest warning in the world. That's no longer the case. There are a number of countries that have surpassed Uruguay in that respect, and a number of others that have similar sized warnings. They also challenge what's being called a single presentation requirement, which in effect prevents tobacco companies from selling more than one variant of a single brand. The rationale being that presenting different variants of a brand alongside one another at the point of sale suggests to consumers that some of those products are less harmful than others. And of course, this builds upon a long history of tobacco industry misconduct, in the sense that the industry marketed products like light, mild, ultralight, suggesting that they were in fact less harmful to health, when the evidence was to the contrary, that in fact there's no difference to human health because smokers compensate primarily to service their nicotine addiction. The claims fall into sort of two main arguments. The first is that these measures indirectly expropriate or take away Philip Morris property rights, specifically trademarks and goodwill. And second of all, Philip Morris relies on what's called a fair and equitable treatment provision and argues that the treatment is unfair and inequitable. In each instance, the company is arguing that Uruguay cannot establish that these are effective public health interventions, and therefore it's not reasonable and it's not a proportionate response by the Uruguayan government, places a disproportionate burden on the company's property rights. And that question of evidence underlying the public health interventions by Uruguay is an important one. It's one that we'll come back to in each of these disputes because it's now the primary avenue through which tobacco companies are seeking to test tobacco control interventions under trade and investment agreements. Just as a sort of a footnote to this dispute, at the time it was launched, I think from memory 2010 was when the request for arbitration was filed. Philip Morris said this was a claim for billions of dollars. And Chris has already mentioned the suggestion that this is an intentional approach to try and discourage the Uruguayan government from maintaining this measure. I think there's no question about that. And when we see that, in fact, when it comes time to naming the amount that Philip Morris can substantiate as its loss, or reasonably thinks it can substantiate, it's a claim for $25 million US. That's not to say it's a small amount of money, but there's obviously a gross disparity between the rhetoric of a claim for billions of dollars under an investment treaty and the reality of a claim for $25 million US. As it stands today, this dispute is, I think, in its very final stages. The parties have been making their oral arguments and their final written submissions this year. It's not entirely clear when we'll have a decision from the arbitral tribunal, but perhaps it could either be this year or perhaps in the first half of next year. Philip Morris has lodged what is in some respects a similar claim against Australia. I'll come to the similarities in a moment. It's a very different measure at stake. Here we're talking about plain packaging of tobacco products, and you can see the image on the slide. Plain packaging, the key features of it are that branding is permitted on the pack only in the form of a brand and variant name in a standardized font, style and size, and the rest of the packaging is standardized. This implements guidelines to Articles 11 and 13 of the Framework Convention on Tobacco Control. Australia is the first government in the world to have legislated for plain packaging. Ireland and the United Kingdom have also done so this year and expect, at least under their legislation, to implement in May next year, but we'll come to some legal disputes around that in a moment. And then there are a number of other governments that are hot on their heels and I think very close in policy development or legislative processes. This is a similar claim to the Uruguay claim in the sense that Philip Morris is relying on the same substantive legal protections. So it argues that plain packaging constitutes an indirect expropriation of the company's trademarks, goodwill, and also that again the measure is not consistent with the concept of fair and equitable treatment. And again, they base these arguments primarily on questions of evidence. They argue that there's no evidence that it's an effective intervention, it's arbitrary and imposes a disproportionate cost on the company. In this claim, proceedings have been bifurcated, which basically means that Australia is challenging the jurisdiction of the tribunal, arguing in the first instance that the tribunal does not have jurisdiction, and in the second instance that even if the tribunal does have jurisdiction, it should decline to exercise it. And it's basing that argument on two primary things. First of all, as Chris has already mentioned, the company restructured its operations after the Australian government had announced its intention to implement plain packaging, and the Australian government says that basically Philip Morris Asia, based in Hong Kong, took ownership of the Australian subsidiary solely for the purposes of facilitating the bringing of the claim, which is impermissible. And second of all, that in that process, in making that foreign direct investment, Philip Morris engaged in some misleading conduct in terms of the purpose for which it represented the transaction to the Australian government at the time, and as a consequence, the tribunal should decline to exercise its jurisdiction. So at this stage, it's a bifurcated proceeding, and the parties are still arguing about this jurisdictional issue. It's possible that the tribunal might dismiss the claim, and we won't get to the merits phase. But we'll wait and see. We may know more about this phase of proceedings and how the tribunal decides either late this year or early next year. Unlike those two claims, there's a separate set of claims under the law of the World Trade Organization. So far I've mentioned a bilateral investment treaty between Switzerland and Uruguay, and in Australia's case, a bilateral investment treaty between Australia and Hong Kong. As Chris already mentioned, there are approximately 3,000 bilateral investment treaties. I think certainly over 2,500 of them in force. They're bilateral agreements. And here we have a separate and additional claim under the law of the World Trade Organization, where a number of members, in this case governments, Dominican Republic, Honduras, Indonesia, Cuba, are bringing a claim against Australia. And as Chris mentioned, Ukraine was the fifth complainant and has recently suspended its claim. And so these four governments have challenged Australia's implementation of plain packaging, and they've challenged it under TRIPS, which is the Agreement on Trade-Related Aspects of Intellectual Property Rights, and the TBT Agreement, which is the Agreement on Technical Barriers to Trade. And they argue, first and foremost, that the measure under TRIPS is an unjustifiable encumbrance on use of their trademarks in the course of trade, and therefore violates the agreement. And second of all, they argue that plain packaging is more trade restrictive than necessary to achieve a legitimate objective such as protection of human health. And again, in each instance, one of the core arguments of the industry is that the evidence that in this case Australia has relied on is not sufficient to support implementation of plain packaging or to justify it under WTO law. Of course, the Australian government, both in the investment treaty claim and at the WTO, is arguing otherwise, and is also naturally pointing to the guidelines to the Framework Convention on Tobacco Control, where the current 180 parties to the convention have agreed by consensus that parties should consider implementing plain packaging. In terms of numbers, this is the largest dispute in the history of the World Trade Organization, with approximately 40 other WTO members acting as third parties, which permits them to make submissions to the panel adjudicating the claim. We expect to see a panel report perhaps midway through next year, and then there'll be the possibility that a party to the dispute could also lodge an appeal, which may take up to perhaps another 12 months. The timelines are difficult to anticipate, however, because it depends very much on how the panel decides to treat the evidence and the extent to which it feels the need to delve down into it. Outside of bilateral investment treaties and the World Trade Organization, and in fact free trade agreements, we also have customs unions. Customs unions are like a single customs territory where we see free movement of goods within the territory and a single external border for purposes of trade. The European Union is, I think, probably the most prominent example of a customs union. And it's worth stating that in customs unions we see, I think, much greater integration, including positive integration in a regulatory sense, than we do, say, through the law of the World Trade Organization, which is more or less a system of prohibitions. And under the law of the European Union, the European Commission has certain powers to issue directives, including in circumstances where there's a barrier to free movement of goods. And the Commission has used this power to issue a tobacco products directive, most recently the 2014 Tobacco Products Directive. And so this is, in fact, as odd as this might sound, it's an example of an agreement for trade integration or liberalisation in many respects, that through this system of positive harmonisation or integration on regulatory measures has in some respects permitted EU member states or dragged some EU member states up in terms of their standards of tobacco control and required them to implement measures that otherwise they might not. Of course, the 2014 Tobacco Products Directive is being challenged on a number of different fronts, including with respect to a passage on plain packaging that would allow or states that EU member states are permitted to implement the measure. In addition, as I mentioned earlier, Ireland and the United Kingdom have legislated to implement plain packaging and are facing claims through their domestic courts that basically invoke EU law and argue that the measure is contrary to EU law in a number of respects. Again, this relates to protection of property rights, protection of free speech and fundamental rights and freedoms in the EU context. Finally, I would just say in terms of the timing of those claims, May 2016 is the deadline for transposition of the EU Tobacco Products Directive into the domestic law of EU member states, and Ireland and the United Kingdom intend to implement plain packaging at that time. So I dare say that the courts in Europe will be working to resolve this issue before then. Finally, because I work at WHO, I should say something about WHO's role. We provide training and technical assistance, capacity building on trade and tobacco control measures to member states. We speak at relevant committees in WTO, and we've also taken the more active step of submitting an amicus curiae brief in Philip Morris versus Uruguay. The brief was admitted by the tribunal, and in the process the tribunal rejected arguments by Philip Morris that WHO is basically a partisan in the dispute supporting tobacco control measures. This is, I think, fair to say, uncharted territory for WHO, but a very welcome development in terms of WHO's posture on these issues. So the big question, what happens next? And I've already seen in the, I guess, Q&A panel on the webinar a question from Rob Eckford about other investment treaties and the TPP. So let me come to what happens next outside of the domestic US context and getting the TPP passed or not. There's a very big political window that's been opened around investment treaties, and it's been opened partly by these claims by Philip Morris and also partly by comparable claims in other sectors from foreign investors. And it would be a shame, I think, for public health to think that the deal that's been done in the TPP context is somehow a solution to all of the public health concerns associated with investment treaties. And it would be a shame also in a way to leave the table without having some positive solution in that respect. So here we have a new agreement that's been negotiated in the TPP, and in reality the language in the TPP investment chapter is going to be more deferential to the rights of states to regulate than the language in most existing bilateral investment treaties. And the United States has something like 120 of these. And so in some ways, I agree completely with Chris and Greg that this is an important milestone, that it's a big step for 21st century investment treaty negotiations. But the tobacco companies are extremely aggressive litigators, and they're abusive litigators, and they're unlikely to bring claims under the TPP. They're more likely to bring claims against governments under older investment treaties that don't include the kinds of language and deference to domestic regulation than will be found in the TPP. So if there's still scope for political deals to be done in the United States, then one deal that tobacco control advocates and state-based legislators might work towards is to ensure that if the TPP is passed, that the USTR will then go away and work towards cleaning up the rest of the bilateral investment treaties and investment chapters in free trade agreements that the United States is a party to. Because the reality is that unless the United States government does that, the TPP is something of a fig leaf and is in some ways just for show. So as I said, I agree completely with Chris and Greg that this is an important step, and certainly before my life at WHO, excluding tobacco from investment treaties is something that I advocated. But it's also sobering to consider the number of other agreements that are already out there and the fact that they have terms that are worse for regulation than the TPP. And I think that the political window here isn't closed, and that there's a chance for those of you in the United States to continue to take this issue forward. And certainly we're seeing other countries do that, and discussions in the European Union are an example of that. And so I would hope that you know, there's some celebration, but also still a lot of momentum to be built and work to be done. And I'll conclude there. Thanks very much, Doug.
Thank you very much, Ben. We've come to the end of the hour, but our panelists have said they would be able to stay a little bit over, and given that, I think we will continue for a few minutes just because we do have a couple of questions that have been posed, and we invite the audience to stay with us if you are able. One of the questions that's been posed involves the fact that under the language introduced within the TPP, as it's been described so far, it is an opt-out clause, and the question is whether incorporation of this language is likely to set a precedent for future trade agreements, and if so, is that dangerous in that it would set the bar too low by not being a complete carve-out for tobacco products? I'll invite any of our panelists who have a view on that to weigh in.
Well, Doug, this is Chris. I'm happy to start, and I'm sure the others will have something to say too. When we set out to work on the TPP, it was because we were hoping to set a precedent. So I think that this will set a precedent. My hope is that this sets a new floor, and that as we move forward with educating governments on the nexus between trade and tobacco, we can improve upon this in future trade agreements. But I completely agree with Ben's closing comments that this is a step in the right direction, but there's a long way to go.
Any other panelists care to weigh in on that as well?
Yeah, this is Greg, and I agree with Chris that the TPP agreement is the beginning. And that more work remains to be done, and as Ben, clearly said, we've got to figure out a way to deal with all of the existing bilateral investment treaties and other free trade agreements out there that still give the rights to the industry to do the abusive things they've been doing.
Thank you, Greg.
And since Greg dove into the second question as well, and Ben commented on it, I wanted to just let everyone know that we have been thinking about the existing bits, and when we set out 5 years ago, we had a short, medium, and long-term strategy, and the short-term strategy was win on the TPP. The medium-term strategy is to make tobacco carve-outs the new norm, but the long-term strategy is to roll back the existing damage, especially under BITs. And we have been working with legal scholars to develop methods that willing countries that are party to BITs can do a retroactive carve-out for tobacco without having to renegotiate the entire BIT.
And again, Chris, when you use that term BITs, you're referring to these bilateral investment treaties. So it's exactly. Two countries in agreements with one another. Yeah. Greg, you mentioned in your presentation the U.S. Chamber of Commerce and the Farm Bureau. Can you say more about the role that organizations like that play in the development of international trade agreements, and is there anything you can say about the relationship they may or may not have with the tobacco industry?
Sure. First, I would say, answering the last part of your question first, that the relationship with the tobacco industry and the business associations like the Chamber appear to be relatively cozy. We know that Altria, the parent company, Philip Morris, sits on the board of directors of the U.S. Chamber of Commerce. We know that the Chamber of Commerce has been weighing in on tobacco control measures as countries have been considering them around the world to the benefit of the tobacco industry. And to answer the first part of your question, the role of the Chamber and of the American Farm Bureau and other business associations in the development of trade policy is huge. I can't emphasize that enough. They certainly have the attention of the trade ministries, and they are viewed as representatives of a variety of the business interests and sectors as those various businesses and sectors advocate for the opening of markets around the world for their products and services. And so I think that you're right, Doug, to point out that, we've got some formidable opponents to some of the things that we're trying to do as we change the dynamic of how tobacco is treated in the trade context.
Thank you, Greg. Another questioner points out that while the panelists have talked about the role of the tobacco companies, the only one that we've identified by name is Philip Morris. And so the question is, are other global tobacco companies involved in these issues as well? And do you folks have any thoughts about how we can manage a coordinated global response?
Well, I can jump in real quick and say that Philip Morris is not the only multinational tobacco corporation to use international trade law as a weapon. British American Tobacco has been deeply involved in the WTO disputes against Australia, and going so far as to admit that they covered some of the litigation costs for Ukraine and one of the other countries involved. I should also point out that when Ukraine launched that dispute, Ukraine does not and has never sold tobacco to Australia. And so it was entirely because BAT was willing to pay for litigation, in my opinion, that Ukraine was willing to launch a suit like this. How it's going to be managed on a global level is, I think, the same way we've managed to build a tobacco control movement globally. I think the FCA is going to be central to it. I think we're going to need to get a group of governments, a coalition of the willing, to insist that in their trade agreements they treat tobacco uniquely.
Thank you, Chris. And this will be our final question. Someone is asking Greg, with regard to your discussion of the benefits of tobacco control in relation to the alleged benefits of expanded trade, the question is, can you point folks to some good references or authority that they might be able to use on that topic?
It's difficult to say that we have a good source for the net benefit versus the net harm tobacco to trade, but we certainly have sources for the harms of tobacco for worker productivity and for the consequences for health care and the impending disastrous, impact of tobacco for, cancer and heart disease and that sort of thing around the world. We've got information from the World Bank, from the Council on Foreign Relations, from the Harvard School of Public Health and others that document a number of those issues. And actually the World Bank has considerable concern about the interference of tobacco with the economic development of low-income countries in particular. So there are good neutral sources about some of those elements. But we do not have a net benefit, net cost to actual trade transactions themselves.
Well, thank you for that. And I want to thank all of our panelists for the outstanding presentations, and I want to thank the panelists and all of the attendees for remaining with us as we've run a little bit over, but I hope you will all agree that the topic was worth the investment of our time. So with that, thank you again to the panelists and to the attendees for joining us today. That concludes our webinar. Thank you very much.